Welcome, welcome, welcome. And two more welcomes. Welcome to everybody, whatever state you're in, whatever political side you are in, part of our continuing series where we talk to professors, reporters, writers, columnists, activists, anybody on the left, anybody on the right, anybody who can form a complete thought and provide some sort of insight into political polarization and how we got here in America today. With us today, it's our pleasure to have Herbert Kritzer. Herbert Kritzer is the Professor Emeritus, the Marvin J. Sanoski Chair of Law and Public Policy at the University of Minnesota, driven to discover. I joined the law school in 2009 from William Mitchell College of Law, where he taught empirical legal studies, politics of legal policy, and statistics for lawyers. He's a leading scholar on the legal profession, the work of lawyers, and other aspects of the American civil justice system and state judicial selection. He's an affiliate professor at the University of Minnesota's Department of Political Science. Previously, Professor Kritzer was a professor of political science and law at the University of Wisconsin-Madison, chaired the Department of Political Science, 96 to 99, was the director of the Legal Studies program from 2000 to 04, visiting fellow, faculty of law, University College of London, 86 to 87. He also taught political science as an assistant professor at Rice University, 75 to 78, visiting assistant professor at Indiana University, 74 to 75, and he was instructor at the Inter-University Consortium for Political and Social Research Summer Institute at the University of Michigan, 74 to 77. The professor has written more than 100 journals, articles, and book chapters. His most recent book is a study of the contingent legal fee practice in the United States, Risk, Reputations, Rewards. He co-edited with Peter Kane the Oxford Handbook of Empirical Legal Research. He is associate editor of the Journal of Empirical Legal Studies, the former editor of Law and Society Review, and a regular peer reviewer for leading political science, law, and social science journals. He has received numerous grants and awards, including several from the National Science Foundation. I think we covered most of that. And this was the article where I found the professor, Politicized Justice, Changing Patterns of Decision-Making in the Federal Courts. But before we get to that, let's check in. Professor, did I say anything wrong? Did I get anything wrong? Is there something we need to correct?
The only thing I would correct is that the contingency fee book was from several iterations back. The most recent book published was on state judicial selection and states changing their method of selection. And prior to that was a book on state Supreme Court elections from approximately 1946 to 2012.
So it's fair to say that you're kind of at the nexus of law and politics, or public policy, or political science. You're familiar with law, you're familiar with the court system, you're familiar with judges and lawyers, but you're also familiar with the concept of politics and political polarization. And I think that's the nexus of this article. I was reviewing it, and it looks like what you're saying is many people view the courts as the Lady Justice, right? She's blind with the scale. I have no biases. I only look at the information in front of me. But it looks like you're saying that's changing, or has changed, that there seems to be some sort of political polarization at the federal court level. Although I think you said not on the issue of economics. Is that fair?
So when I looked at all three levels of the federal court system: the trial court, the intermediate appellate court, and the Supreme Court. The best data I had was for the trial court and the Supreme Court, in the sense that it went through more or less the period, the entire time. The Court of Appeals data ended somewhat earlier. What I found looking at the Supreme Court was a very clear polarization on civil liberties and criminal law issues, polarization based on the party of the appointing president. That had occurred over time. I didn't see it at the time I looked at this so much for economic regulatory issues. I didn't see the same kind of polarization. When I looked at the lower courts, it varied a lot depending on very specific issues. The overall pattern, particularly at the trial court, the federal district court, was a clear degree of increasing polarization but that appeared to reflect more the Republicans becoming more conservative, Democratic appointees staying roughly where they were in terms of their conservative versus liberal decision making. There was a little more divergence at the Court of Appeals level, but those data stopped about 15, 20 years before the other data that I looked at.
So at the lower court level, there was definitely a trend of polarization, although it's a little bit more of a mixed picture, but it's mostly coming from the Republicans. However, when you're talking about the Supreme Court, you say that there's polarization. Is the polarization at the Supreme Court level also primarily coming from the Republicans, or is it coming equally from the Democrats and Republicans?
It's less distinctive. It's clearer on the trial court level than the Supreme Court level.
Okay.
It's possible that the Republican appointees have shifted more to the right than the Democrats shifted to the left, but I believe I found that both of them were shifting.
It's possible the Republicans moved further to the right, but both have moved.
Right.
When did this start, in your opinion? I mean, is it how? Because a lot of people are going to look at Amy Coney Barrett, and they're going to look at that was the kingpin that made the Supreme Court more conservative, turning it back to like I think the 1970s court level. But I'm betting there were signs of polarization before Amy Coney Barrett was appointed.
I wasn't even looking at it after she became a member of the court. I was looking at it prior to that.
Okay.
So what you began to see in many ways was that the Republican appointees were more clearly conservative, and the Democratic appointees were more clearly liberal. You did not have a John Paul Stevens. You did not have other Republicans who tended to be either more liberal or at least moderate in the case of Sandra Day O'Connor and to some degree Justice Kennedy. And likewise on the Democratic side, you didn't have any examples such as Byron White, who was more conservative than most of his Democratic appointees on the court. And if you go back, you see that there was the presidents up until Nixon were not that concerned about the ideology, although because you see that at least two of President Eisenhower's appointees, Earl Warren and Justice Brennan, were quite liberal. And when you get to Democrats, if you go back to Truman, you find justices appointed by Truman who were fairly conservative.
So when does it start? I heard you say before Nixon, this wasn't an issue. When I've looked into this and I look at polarization on the courts, the first big milestone, according to some historians, seems to be the Robert Bork attempt at appointing him to the Supreme Court. The Democrats attacked him viciously. The Republicans felt that was polarizing. But I'm feeling like it has to do more with something even more closer, like something in the 2010s, 2015s. When do you feel polarization on the court became noticeably bad?
Well, bad is a question of perception. I mean, it clearly has increased. There's always been some difference on average, or at least long been some difference on average between appointees of Democratic presidents and appointees of Republican presidents. At least, certainly through much of the 20th century. You go back and you look at what happened during the Depression and the Republican appointees who were striking down Roosevelt's New Deal programs. So there it was much more concerned about economics initially, but it shifted in time over to more of a concern about civil liberties issues. So when you say when did it start? I mean, it's arguably somewhat endemic at the Supreme Court level that presidents have generally appointed people from their own party, and Democrats historically have tended to be more liberal and Republicans more conservative. There were some cross-party appointments, but not many. Um, but you see this pattern of a distinction between the two sides for a long time. That's true at all three levels of the federal courts. There's evidence of difference patterns between Republican appointees and Democratic appointees through much of the 20th century. The question is really, have those differences become greater over time? And when did that start?
Right.
And I would argue that it probably did start with the Nixon appointees, albeit, it became even clearer with the Reagan appointees. There was much more of a emphasis in the Reagan administration to find justices who they thought would be conservative in their decision making.
Some historians, so you're saying it starts with the Nixon and Reagan era, where you're kind of going against this long historic American trend of, I just want a good judge. And now they're trying to pick judges who are on their ideological side and will continue to rule in that ideology.
I'm not sure if I would use the phrase, I'm just trying to pick a good judge. I think you certainly am trying to avoid picking bad judges.
Okay.
Historically, at the trial for the federal trial courts, federal judgeships were very much political patronage positions.
Okay.
And the state senators, particularly the senators of the president's party, had a great deal of say. Some would argue basically they named the judges who were going to serve in their states. And some of those judges were pretty bad judges. Many of them were very good judges. Some of it had to do with the ideology of the state senators. So particularly if you look at some of the judges appointed in the South, even in the Kennedy administration, they were diehard segregationists because the state senator, who had, particularly at that time, the Southern Democrats had a lot of power in Congress through seniority. They had a lot of say, and Senator Eastman from Mississippi was the chair of the Judiciary Committee. So, you had to keep him happy. And one of the people who was appointed was his old college roommate, a guy named Harold Cox, who was notorious. He was known by some as Weird Harold because he had not seen a integration case that he liked ever.
He got his college roommate in? Wow.
Oh, yeah. I mean, there's a book that was published back in the 70s called by a guy named Donald Dale Jackson. And, the line in that book in terms of federal judicial selection is that, you've got to know somebody who was a future U.S. senator sometime relatively early in your life.
So it was never perfect. There was lots of things that weren't good about it, but we didn't have presidents saying, I want to have a Supreme Court judge that aligns with my political party, and that was the way that they were selecting judges till roughly Nixon, Reagan. Would that be a fair summary?
Not entirely, because again, go back to Roosevelt, and so he wouldn't say, I want judges that are aligning with my party. He would say, I want judges who will support my economic program to end the Depression.
Okay.
And so he was very much picking people he thought would back the policies that he and the Congress were passing. It was, less so. And if you look at Truman, I think Truman was much more looking at people he knew. Eisenhower, I think, it wasn't really clear what he was looking for in terms of the people he selected. There's a story about the selection of Warren, who was a Republican but turned out to be a very liberal Republican on the court, that basically his selection was partly a payoff for his support of Eisenhower at the 1952 presidential convention. Whether that is actually true is not 100% clear, but it's often described as part of the reason that Warren became Chief Justice.
A lot of people look at the debate over Merrick Garland. When Barack Obama was president, he wanted to appoint Merrick Garland as a Supreme Court judge. He felt Merrick Garland was moderate. I'm not really getting into that, but Obama at least seemed to try. And the Republicans did at least something that was considered strange at the time, which was they said, we're just not going to entertain any idea of whoever you want to put up for the Supreme Court. A lot of people felt that that was very politically polarized and kind of a shutdown of normal governmental functions when we look at the appointment of judges. Would you agree with that, or would you point to an earlier time and say, well, it was just as bad at this earlier time too?
I'm not sure I'd say just as bad, but there certainly is the example of Earl Warren in 1968 announcing that he would retire upon the selection of his successor. And then Lyndon Johnson nominated Abe Fortas, who was a sitting justice on the court. It was Justice Fortas's nomination was opposed by the Republicans, and they could not get it through. And so Fortas withdrew, and Johnson decided not to make another appointee nomination. And then you have Nixon winning the election and Warren Burger being
right
named as Chief Justice. So you know that's a little bit similar to it, but there was certainly an ideological element to it. I mean, the opposition came very strongly from Southern senators, and so that's a little bit similar. The fact that we had the failure of the Garland nomination certainly had a huge impact ultimately on the court.
I've seen people point at that and say, we've never seen one party say we're going to deny the president a right to, and again, this is just what was in the popular press. I'm not asking if this was accurate. I'm just telling a story. This is what the popular press was saying. Oh, we've never seen this before. A party just say, we're not going to entertain your idea for a Supreme Court justice. And that was seen as pretty bad. And then you fast forward to Brett Kavanaugh, and boy, that seemed like the wheels came off the cart. People were
don't you mean Amy Coney Bryant?
Well, didn't she come after Kavanaugh?
No.
Okay. Well, both of them.
She was the replacement for Ruth Bader Ginsburg.
I saw people become very upset with the appointment of both of those judges, and it seemed to be that they were very politically charged events for both of them, and people were, at least in California, saying, oh my God, they're going to take away all our rights, and they're going to return back to the 1970s level of conservative court, and just a lot of very visceral reaction. And so people kind of go, well, if we look at those Barrett and Kavanaugh, did it just start there? Well, they kind of look at Merrick Garland and they go, well, that was sort of a breakdown in process earlier. So there's some people dating at least to Merrick Garland, but it sounds like you're saying we had problems the whole time. It was never perfect.
It's a history of rejection of Supreme Court nominees. There were two nominees of Richard Nixon's who were rejected by the U.S. Senate. The Senate was democratically controlled. The true underlying basis of the opposition was ideological. They were both Southerners, and I think they were both. The Democrats feared they would be less supportive of civil rights, and that's what eventually got us the Minnesota Twins, as they were known.
Could you tell me about this chart here? I found this one chart and I found it very interesting. What is this chart telling us?
Well, it's just telling us in terms of the kinds of cases the Supreme Court actually issued decisions on, that the issues changed over time. What you see most clearly is a sharp drop off in cases dealing with economics and regulation, particularly up through and into the Warren Court period. It's a fairly steady decline, and then it varies. And what is increasing clearly are criminal cases and also the civil liberties cases. So economics is 40 to 50% of the court's decisions through the Warren Court, and post the Warren Court, the civil liberties and economics case, civil liberties and criminal cases are roughly 60% or more.
So there's a big transition. Obviously, this trend is going down from the Hughes Court to the Warren Court, but there seems to be a big new normal after the Warren Court, where we're not primarily looking at economics issues. We're looking at just civil rights, civil liberties, or criminal cases. Is that a fair statement?
Okay. That's a fair statement. I mean, civil liberties and criminal justice really largely took over the agenda.
And when was the Warren Court, for everybody watching at home? Roughly
Warren
what
Court
time?
Was 1954 through 1969.
Okay, so we're ending the 1960s, and the Supreme Court is definitely starting to focus more on civil rights issues.
Let me correct that. 1953 to 1964, I believe.
Okay.
53 or 54.
But it stops right in the heart of the very volatile 1960s.
No, at the end of the 1960s.
Okay. And then it transitions. What does that mean to you? That is this a good thing that we stopped talking about economic issues and we started focusing on cultural issues and criminal issues? Because the first thing in my head is, if there was that many things to debate about economics legally before, our economic system has only gotten more complex.
Except there was a lot of the economics cases dealt with labor relations and dealt with regulation, the new regulatory state and what regulatory agencies could and cannot do, which the regulatory state really started growing during the Roosevelt administration. And so over time, those issues got worked out. If you look at, for example, at state Supreme Court dockets and how they've changed, the kinds of cases that are decided change over time. If you look at the late 19th century, latter part of the 19th century, they're deciding a lot of property cases, for example. By sometime in the 20th century, they're deciding very few property cases because the issues get worked out and the law gets settled, and so they don't have to decide those in the same rate. So there's something similar going on here in terms of economics cases. Typically have to do with the power of the federal government, what the government can and cannot do in related to commerce and regulation. Now, there is a chance that will increase again, because there was a major decision in 1984 which reduced the power of the federal courts to review agency decisions. And there is a case on the docket for next year, which is a challenge to that existing precedent. And so if that precedent is overturned, one result may be there will be more economic cases coming to the Supreme Court, because more issues will again have to be worked out.
So there's an upcoming case that may change precedent, where the court may have more ability to review federal agencies.
Trial court or lower courts will have more ability to review federal agencies, and that could produce more Supreme Court cases assessing whether or not the decisions of those lower courts were appropriate.
So instead of having an administrator of the EPA just decide what the regulations should be based upon their interpretation of the will of Congress, in theory, we may have courts making those decisions.
Deciding whether or not a regulation was allowable given the authorizing legislation.
Okay. Okay. So they may actually be striking down congressional laws?
No. This would be, reviewing court decisions with regards to how the agencies have interpreted and applied statutes and their authority.
Up for review, possibly. Okay. Would you, I guess the bottom line is, would you say that the federal court system and the Supreme Court system is still functional now compared to the way it was in the past? Or can we say it's definitely has some problems?
I think that's sort of depends upon your political perspective. Certainly, conservatives thought there were lots of problems before, and increasingly it's liberals who are thinking there's lots of problems as both the precedents change and the staffing changes. So that's how you assess how well the court is working is very difficult to disentangle from your political preferences.
It's fair. Pew Research does surveys on a lot of things, and they've surveyed the American public's perception of the federal government and all the branches for many decades. America has the lowest faith in all forms of the federal government except for the military. That includes the presidency, the Congress, and the Supreme Court and the Senate in the last 40 years. According to Pew Research, it's bad. Secondly, when the Supreme Court overturned Roe v. Wade and passed it back to the states, you had a lot of people go on TV and say, I defy the courts. I won't follow the Supreme Court. My understanding from political science historians is that's really new. We didn't have people in the 1960s saying, I don't care what the court says. I'll do whatever I want. Now we have high elected officials and TV commentators and professors publicly chanting it.
Have you ever heard of the term massive resistance?
No.
That was a term that was used in the wake of Brown v. Board of Education by Southern political leaders. We will not obey the court, et cetera, et cetera. So, that is in no sense a new phenomenon.
Okay. But we got to go back to Brown v. Board of Education.
That's the one that is sort of most striking. You could argue that there were similar views with regards to opposition to abortion. That is, those who opposed abortion very often were engaged in activities to try to block abortion, basically to make the right of abortion non-functional. I mean, states passed all sorts of legislation to try to block it. So again, on the abortion issue, you can see things on both sides.
Well, the states tried to, like you said, block the legislation, but it sounded like they at least acknowledged that the court passed that ruling. We got to go back to Brown versus Board of Education, where somebody's saying outright, I don't care what the court says. I'm going to outright massive resistance.
Yeah, I mean, the argument is whether or not the court's decision is legitimate in some sense. Is it
right?
Is it a proper interpretation of the Constitution or the Bill of Rights? And you get people arguing that, throughout. I mean, if you go back and you look at Roosevelt and his reaction to the Supreme Court striking down all sorts of New Deal legislation, he was very critical and kept trying. He'd strike one thing down, he'd try to come up and do it a different way, just like President Biden is doing in regards to the student loan forgiveness decision. He's trying to come up with other ways to accomplish the same thing.
Fair enough. But it does seem like a long time. We have these people very upset at the Supreme Court over Roe v. Wade in 2022, and we got to look back to 1954 and 1930 to find at least similar episodes of just as much angst and anger.
Well, again, 1960, early 60s, and the prayer decisions, many places basically ignored the decisions regarding prayer in public schools. So I think you see it periodically. It depends on the nature of the issue, how much of it's really a kind of a gut level issue for people.
Okay. So at least back to the 1960s. So it's been a couple of decades, maybe about half a century. How do we reduce it? If somebody says it's a problem, if somebody thinks I want to go back to the pre-Nixon level, is there a way that we could do that? Professor, how would we even do that? How would you depoliticize the judges and the appointment of the judges if you wanted to, if you felt it was a problem?
Well, you could adopt a very different method of judicial selection that is designed to reduce the role of political actors in the system. Several other common law countries use a judicial appointments commission, where the commission makes a recommendation to the official that formally makes the appointment, but that official is constrained in some ways, in a way that leads them to basically go along with the recommendation. So, typically what I know in England, the way the system at least did work, and I don't know if they've changed it in the last couple of years, is that the Judicial Appointments Commission would make a recommendation, and the appointing authority could accept that and appoint the person that was recommended, or reject it and go back to the commission and say, I want you to reconsider this. But with whatever the commission then came back with on the second round, the appointing authority did not have the ability to reject it.
Mm.
So the appointing authority could reject essentially one nominee. And the commission is selected in a way that it appears to be pretty, nonpartisan, not closely linked to one or the other parties.
What country? England.
I don't see that happening in this country.
Well,
yes, yeah. Could I imagine a way to do it? Yeah, but I don't see it happening.
Right. So it's possible, but unlikely.
I would say there are systems that exist, but I don't see them being adopted in this country.
Okay. Last couple questions, and thank you for your definitive answers. I appreciate it. It's very helpful to get some clarification on these big issues. What would you say to somebody in California and they see, Barrett and Kavanaugh, and they see the New York Times and ABC television and CBS and NBC and CNN and MSNBC say, oh my God, the most conservative court since the 1970s, here to take all your rights away? What would you tell a Californian who's deeply scared from what they've seen on television?
Well, keep in mind that for the kinds of rights we're talking about, many of it, what the court is doing is saying this should be decided at the state level. So the Californians can just do whatever they want. That doesn't apply to gun control, for example, although it's not yet clear what kinds of gun regulation the states can and cannot adopt. But certainly on the abortion side, there's nothing to date that would prevent abortion, prevents a state from allowing abortion. In fact, just today or yesterday, the state court in Ohio ruled that a proposal to put a amendment in the state constitution protecting abortion should go on the ballot.
Fair enough. And Kansas, I think, had a vote.
Kansas had a vote
to uphold it. Just a lot of scared people. Okay, last two questions. This is my favorite one to ask everybody. You're not you. You're not me. You're a third person watching the video. They've watched the video. They've learned a lot. They struggle to remember it all. But 5 days after they watch the video, there's one thing that the professor said that they can't get out of their head. what is the one thought you want a random person you'll never meet to not be able to stop thinking about 5 days from now after they watch this video?
It would be extremely difficult to eliminate politics from the judicial selection process in this country and the resulting influence of judges' political perspectives from having at least some influence on decision making.
Thank you. I really appreciate it. I hope you found this was a fair interview. Is there anybody academic or activist or just someone you know who you think might be willing to be part of an honest conversation? We always ask, you don't have to answer. We always ask for recommendations, try to keep the conversation.
Well, I looked at who you've interviewed, and you've interviewed a lot of the people I would identify. Have you interviewed anybody at the Brennan Center in Washington?
I don't know, but I can look for that. The Brennan Center. I know about them. I'll start focusing on. Is there any particular names you might think might be good?
No, I'm not sure who the person is at the moment. There is one person who does currently head up the program related to the judiciary. They're focused mostly on state judicial selection.
Yeah. Still, you said that the polarization was appearing at the lower courts level. I guess that's the lower federal courts, not state courts.
Right.
Is there any signs that polarization is appearing at the state courts level, or is
there is some? There's certainly evidence that the election of state Supreme Court justices is becoming more polarized in the states where the justices are elected. That's pretty clear.
Oh, okay. So it's going throughout the entire court system. It'd be fair to say it's going throughout the entire court system, through the federal and through the state.
I think it varies to some degree from state to state in actuality, and both in terms of whether or not decision making in the state has become polarized. For example, in the Wisconsin State Supreme Court, it's become extremely polarized.
Right.
In the Minnesota Supreme Court, it has.
So okay.
It varies.
Okay. So it's not sweeping everywhere. Some places are resisting it. Maybe we could learn from that. We could learn from the states that aren't being as polarized while their neighbors are.
Well, the best explanation for it has to do with the decisions the court is making, and that has something to do with the nature of the legislation that is passed and is challenged in the courts. So I think the big difference from Wisconsin and Minnesota, it arises in significant part from the state passing some tort reform legislation that the state Supreme Court struck down. There has been no such legislation passed in Minnesota. So the court has not been called upon to strike it down.
We'll leave it there. I want to say thank you for coming out, Professor. Thank you for answering all the questions. Thank you for clarifying things. I'm trying to learn too, and I really appreciate you going, no, it's not like that. It's like this, because that's what the point of this interview series is, to get answers directly to the public, to take academic research and make it so the average public can understand. So I really appreciate you being blunt and decisive with your answers. It's very informative, and it helps people understand what's going on. Thank you very much. I will email you shortly a copy of the interview, and I want to say thank you for coming out.
Thank you. Bye-bye.